So good morning, everyone. Warm welcome to you all to come to our seminar today, where we're going to talk about community standards, the modern workplace, and just explore in detail some of the decisions coming out of the tribunals, just to see if they reflect what we say the community standards are today. We're delighted to present this seminar to you, and we also welcome the people who are on our web. We're regularly hearing from clients that you want to know how will the Commission decide a case. That's always a tricky one to answer. Typically, we're asked questions about what will a Commission do if you've got someone that you're finding they are either making racial remarks that are offensive, they're perhaps engaging in conduct that constitutes sexual harassment, or you might find that they're just generally engaging in inappropriate conduct that doesn't align with your standards, and you want to know what sort of stance you can take against that. So today, that's what we want to explore in a bit of detail. I have got two of our fabulous lawyers in our team, the Workplace Law and Culture team, who will sit on our panel and look into, they get the fun part of this because they get to talk about the intricacies of these cases, and I get to ask the questions. So it's interesting to think about, if I turn to the topics that we'll cover. I've already flagged that these are the three things that we'll look at, but it's interesting to think about community standards and what is acceptable and what's not acceptable. You tend to find that evolves over time. So, some might say that we're an outraged society, political correctness has gone mad, but then you might find others, particularly people who are part of the Me Too movement, who would find that it's all a bit too little too late, and that there's still a long way to go. So finally, we will look at what are the mitigating factors, because we're in a tricky jurisdiction, and mitigating factors are something that the tribunals need to look into. So often you'll find it's not just a straightforward path, that you have got conduct that might represent a valid reason to terminate someone's employment, but there might be this mitigating factor sitting out there, which we like to also call or reference as the bite back. So we'll explore that as well. This is just a quick snapshot, because we're not really talking about the unfair dismissal processes. We really want to get into the case law, but it's just a refresher. The takeaway point that I really want to make about this is that there's this tension with the jurisdiction. You can have, as I said, a valid reason, but it might be harsh, unjust or unreasonable. So it might fall over on that basis. So we find that often causes problems for employers, just to try and work out and get that tension right. There's no hard and fast rules, and you tend to find that it's that uncertainty that the jurisdiction brings to business. So really, and it's also the uncertainty that it sends a message to those misbehaving employees, which is my favourite topic, I have to say. So, what are community standards? Look, you find courts and tribunals will often reference community standards. Probably the takeout points that I would come from what I've read from case law is really that it changes. So with time, community standards evolve. And you also find that from the Fair Work Commission, there's been a full bench decision where they've commented on community standards and really said that the laws have to also change, otherwise you're at risk of being archaic. So I think the important point is to understand that it does evolve, and I like this quote because I think that reflects that position. But what about today? What do we say are community standards? These are just some of the news articles, or news headlines. If you feel that the news reflects public sentiment, and that's probably a debate for another time if you don't think that it does. You only have to look at the headlines to get a feel for what the community sees as appropriate or inappropriate behaviour. So from this slide, we've just taken some of the things that we think are, have been a bit more of the more high-profile comments, and I'm pretty sure you'd all have seen these in the news. I mean, you have Eddie Maguire, who is a repeat offender. First of all, he was on air suggesting that Adam Goodes from the AFL should be used to promote the musical King Kong. And that was only days after he was racially abused by someone who was a supporter of the Magpies team, and something which Eddie Maguire had publicly gone in and supported him for. So, you've got comments like that. Again, he also makes a drowning joke on Triple M radio where he says he'll pay $50K to see the journalist Caroline Wilson under a pool of iced water before describing her as a black widow. You've got Alan Jones up there as well. He's also a repeat offender. No surprises there. He came under fire for telling our Prime Minister, Scott Morrison, to shove a sock down Jacinda Ardern's throat after she urged Australia to act on climate change. That was earlier this year. I wonder how that sort of comment would go with if he said the same thing to Greta Thunberg, the 16-year-old Swedish environmentalist, who's also been considered in the Times magazine as to be the next generation leader. So we've got this new generation coming through, which I think is important because if we think about community standards evolving, presumably they're the people that are going to be leading. So I'm going to have some active participation from the audience here, because what I would like to know, to see if this reflects, our audience and the public community, to see whether or not we are outraged by these comments. Who here, if I can get a show of hands in the room, thinks that Eddie Maguire should have been sacked for his comments about Adam Goodes?
We don't happen to have 2GB's HR manager here,
Yeah,
do we?
no? Be helpful. Okay, what about for his comments about drowning a woman on Triple M? I'm going to say yes.
Yeah.
Okay. So I do think it does. Maybe the news does reflect community standards. So let's look at some decisions. Before we do that, just a little light-hearted look at it. This is a clip taken from The Office, one of my favourite shows. And if I can work out how to play it.
Just one more click, should be fine.
Do I just...
You seem a little bit agitated, Michael. What's the problem?
The problem is that I am the boss, and apparently I can't say anything.
Well, that's true in a way. You can't say anything.
Where's the line? Where's the line, Jan?
Do you need to see the video again, Michael?
No, I've seen the video. You talked the whole time. No, I didn't. What?
Of women, so in inappropriate posters of women. So I think we are changing. I think it's a light-hearted look. Obviously, you can say something, but it's just got to be appropriate. So I now am going to ask some questions of our fabulous team. And Ryan, I would like to turn to you first. Perhaps if you can just talk to us about some of the decisions that you found when you look at racial remarks and whether or not you think that the Commission has moved or progressed. How are you finding?
Yeah, absolutely.
that?
You see, we started with from this. Now, that would indicate that that's perhaps where we've come from. I'll talk about where we've gone to. We haven't had to go back too far in order to find a position that arguably doesn't reflect community standards in the decisions of the commissions. Now, for the purpose of these decisions, and we kind of go back and forth through today, but we're talking about the Fair Work Commission, which applies to generally private sector organisations. We will also touch on the Industrial Relations Commission as well, which is mostly public sector. But this decision of Lynn Fox versus Mr. Stutzel is 2012. It's a full bench Fair Work Australia, as it was then, decision. Mr. Stutzel was dismissed for comments on his Facebook page, some of which there was some sexually very inappropriate comments as well. But in terms of race, he made some comments about one of his managers who was a Muslim and referred to him as that bacon hater. There was also plenty of comments about terrorist camps and deaths of terrorists and some really, really inappropriate things. And yet, when the Fair Work Commission, or Fair Work Australia as it was then, decided the case, they decided that the dismissal was unfair because the applicant, Mr. Stutzel, didn't know that his privacy settings were so loose and were able to be read by anyone, and it was more of a vibe of people having a chat in a pub was the comment section, which he didn't know that he could delete comments apparently. So that's only as far back as 2012, some appalling comments, which I would have thought were valid grounds for dismissal, were found an unfair dismissal. Then if we look even as recently as 2012, Mount Arthur Coal, a BHP company, versus Mr. Goodall. Now, that's the full bench appeal, and it's the Fair Work Commission. Some comments over a radio at the end of a night shift. So this guy had been working about 12 hours, and at the very end of a night shift, he should have had the radio available for safety reasons. Instead, he was having banter with, what he called banter, with a colleague talking about how Muslims are effed up after 4,000 years of inbreeding. They were talking about how reasonable the Reclaim Australia movement is. Again, there was some sexual inappropriate comments as well. Those recordings were available to be heard by anyone in the workplace. So this guy didn't have the defence that Mr. Stutzel had, where it was just in private conversation. And yet, he was dismissed, and the dismissal was found to be unfair. He was reinstated. So it would be interesting if that decision came up today. I would like to say it'd be very surprising if the same result was reached, but we're talking only 2016.
Yeah. Look, I mean, my view is that particularly the Goodall decision, there was a very strong dissenting judgment. Can you
That's right.
tell us about that?
Commissioner Johns was in dissent, and I think it's a very important judgment, even though it wasn't what the view the majority came to. Commissioner Johns said, I'm actually quoting him, he said, Mount Arthur took decisive action to eliminate Islamophobia and homophobia in its workplace, and it should have been commended for its actions, not punished by being required to take the driver back. There was no evidence before the Commissioner that fatigue explains Islamophobic and homophobic comments. So that's an interesting point. Actually, you had a heading up there about Roseanne Barr before. If anyone remembers her racist comments, I think it was probably last year, 2018, she tried to say that some medication that she was on was partly responsible for that. And I don't know if anyone saw on Twitter, but Sanofi, the company that made that medication, came out and said, there's lots of side effects for medication. We're not aware of racism being one of those side effects. So Commissioner Johns kind of goes to a similar thing there. One of the mitigating factors was that this guy was fatigued and it was the end of a night shift. But should that excuse racist or sexist behaviour? Surely the answer is no. But it was enough in that decision, at least for the majority, to find that the dismissal was unfair.
So obviously, as you said, this was only a few years ago, this case, and it went all the way to the full bench. Do you think it would be, if that same case was tried now, do you think it would reflect, it would achieve the same result?
I think that, that was 2016. Since then, especially from the sexual side of things, Me Too has happened. And so that itself might have been enough to make a different decision. I think that there's been a big uproar about the importance of racial sensitivity and diversity in workplaces. And so I think that it would be a different decision. I think Johns might have had the view that would more accurately reflect community standards.
Yeah,
and actually, if you go to the next slide, Diana, we've got to this. And I won't go through the facts of each of those cases, but we still do have a bit of a mixed bag. There's 4 cases there. You can look them up. The icons are kind of a clue about what each of them is about. But 2 of them there, so Solon versus Chevron and Hand versus Campbelltown, the employee was dismissed for racially derogatory comments, and on both occasions the dismissal was found to be unfair. Solon made some very inappropriate comments about using a phrase that I won't repeat this morning, but a derogatory phrase used to historically describe Aboriginal women, particularly in a sexual context, which was incredibly inappropriate. He was on a bus which had some Aboriginal people on the bus, and yet it was found that his conversation was not meant to be overheard. It was meant to be a private conversation. So you'll see that's 2017. I think that even since 2017, there's been a move in the right direction. Hand, which is the third one down there, was some comments made by a newsreader on a Campbelltown radio channel. I think that the reason that dismissal was found to be unfair was because it was a very unique setting. It was on live radio. There was a phrase used to describe Joe Jackson, Michael Jackson's dad, as a big black bastard, which in the decision, rightly, the commission said, well, that phrase is objectionable in itself because it indicates that either all black people are bastards or something along those lines. The unique part about that decision was that the commission was able to consider, because it was live radio, the actual audio recording, hear very much the context in which it was said, and decided that, rightly or wrongly, the comment was not meant to be offensive, but that it was just a way to distinguish that Joe Jackson from another old white Joe Jackson who is actually a different recording artist. And so it
does strike me that there would be other ways in which you could probably
I would have
distinguish.
thought so. I would have thought so.
And I also think, well, just from taking the show of hands today, that doesn't reflect public sentiment. So, or community standards. So it does seem that there's this patchiness in the decisions coming out of the commission with respect to
and yet if you look at the other two,
comments.
Those two were, there was dismissals that were based in racially derogatory comments, and both were found to be valid dismissals. So we're certainly seeing some decisions from the commission to say that you can take a stance in this area.
So perhaps I can ask Jade some questions about sexual harassment. Before I do that, I like this comment a lot. And I think particularly because it straddles both topics that we're talking about, not just sexual harassment, but inappropriate behaviour as well. This is just a comment that there's no place for bawdy, offensive alpha male behaviour in the workplace. The only thing I don't like about the comment is I don't think it needs to be directed at alpha male. I think it could just be bawdy, offensive behaviour in the workplace. Jade, we're seeing from the news, the Me Too movement, from that sexual harassment in any form is unacceptable in the community. So what can you tell us from the decisions coming out of the Commission?
I think we'd all intuitively agree that the commissions have started to change as well, and are certainly reflecting this, and they're taking a far harder stance. However, that hasn't always been the way. Again, we don't have to jump all the way back to Madman era of the 1950s just to see these decisions. Do you have to go back a little bit further than 2012? Thankfully, I think. So the first one we have up there is the case of Miller, and this was in 2007. Miller was employed as a clerk in the court, and he engaged in approximately 2 years of a barrage of sexual harassment. And there is really no other way to describe it. Multiple women were harassed by him, including in one case placing his hand on a woman's hip and sliding it down over her buttock. In another case, he again touched the same woman on her buttock and said, I've been wanting to do that all night. He attempted to forcibly hug a woman and saying, I just want to have sex with you, as you do. So, believe it or not, in the first instance, the allegations were found to not be made out, so his dismissal unfair. On appeal, some of the allegations were found to be made out, and yet it was still considered to be a harsh dismissal, and he was reinstated. Not in the same workplace, thankfully, but he was still reinstated and put back into the workforce. The reasons for it, and I know we touch on mitigation later on, so I don't want to stumble over Ryan's toes on this one, but some of the reasons were things that the harassment wasn't sufficiently severe. It wasn't overly offensive. There was a bit of a drinking culture in the workplace, not in the workplace itself, but amongst the working colleagues, that kind of blurred the personal and professional lines. And we come back to that later on. Thankfully, the Commission's changed its tune a little bit on that one. So it did find that it was a harsh dismissal. However, I find a little bit of comfort in the fact that in making that decision, excuse me, I do have a cheat sheet for the quote on this one, that the Commission actually said it's only by the narrowest of margins that we found the dismissal harsh. No employee who engages in harassment of any kind could take any comfort from our decision. So it's a bit of a heads up that we're starting to change. They recognise perhaps that there's a bit of a community backlash against this, and yet they still went with it being a harsh dismissal and putting him back into the workplace.
Yeah, well, look, I know today we're focusing on decisions coming out of the tribunal, not the courts, but I think just as a general comment, you can also see that damages out of the court system are on the rise as well. So, and I think that is reflective of community standards. In fact, so much was said in the Oracle decision that they needed to come up to reflect that community standards. So I don't think it's just that we're seeing it in the tribunals, but we're also seeing it out in the courts.
We also saw that a little bit in the Brambleby decision as well, the second one there. So in this case, Brambleby, along with several other employees, sent emails to his home email address from his work email that had some pornographic images attached to them. And he also, importantly for this case, sent one to his work email address and the work email address of several colleagues that also had pornographic images attached to it. And Australia Post dismissed them. And again, this was found to be a harsh and unfair dismissal. Substantial period of prior service, which we come back to later on. Policy was in place but not aware of it. So even in 2014, we are still seeing the Commission perhaps pushing back a little bit on sexual harassment cases.
So, Me Too movement only happened a couple of years ago.
Yeah.
What can you tell us, Jade, from that you're seeing out of the Commission now?
Seeing, thankfully, things have changed. So we should all be happy on that front. However, having said that, it's not a licence to just feel free to dismiss rapidly or quickly without following a proper process. So, for example, in the case of Parker on the top there, his conduct really was pretty shocking. He was a business manager in a car dealership, and when he was working with a 21-year-old trainee, he made bullying comments saying that, "I will backhand you, even if you are a girl, I don't care." And also made sexual harassment comments saying, "Just show them your tits, you'll be fine." He was dismissed for that, and it was upheld as being a valid reason for his dismissal. The court recognised that it was appalling behaviour, it was serious, it was hostile, it was sexual harassment. However, the kicker is that the employer didn't follow the correct process. They didn't do an investigation and they didn't give him time to respond to one of the allegations. So he wasn't reinstated, thankfully, but they did have to pay compensation for it. So this is a reminder that yes, the Commission is all in favour of employers taking a stronger stance on sexual harassment, but follow the process, follow the policies. Go through or forward natural justice, or else kind of losing out a little bit on that one. Thankfully, in more recent cases, so in the other two cases, in Heesum and Vegco, which was the one that has the nice quote that we mentioned before, that one, again, was found to be a valid reason for dismissal. So Mr. Heesum was already on a final written warning, and he made a comment to another employee that he wanted to have intercourse with that employee's sister. He asked another employee, a different female employee, for a kiss. He was already on a written warning. He was dismissed and was found to be a valid reason. However, the reason why I particularly like this is the comment that we mentioned before, where the Commission really starts to realise that sexual harassment just isn't accepted in the community and reflects that in to the actual decision, saying the conduct which I have found Mr. Heesum to be engaged in would, even without the code of conduct and the disciplinary policy, have constituted misconduct and a valid reason for dismissal. So we're starting to see recognition that sexual harassment in and of itself is offensive, but it's also part of a broader offensive behaviour, which we discuss in a little bit more detail later on.
Yeah, I think it's also a really important point to take away. Whilst we always advise that you want to have your core policies, particularly where there's vicarious liability issues, it's not, the Commission will go beyond that. You don't have to have the policy necessarily, or for them to have breached the policy or for sexual harassment to fall within the definition of the policy for it still to be inappropriate behaviour.
Yeah. The final point I'd like to make on that is that the Commission has actually become quite sophisticated in recognising what is sexual harassment. It's no longer the stereotypical of male groping female employee. For example, the last case there, Clark and Toll Transport, that was male on male harassment via text messaging. So they're moving with the times in terms of technology, in terms of the way we engage and interact with people, but also in recognising that it's not simply a male and female problem. So in this case, Mr. Clark was a driver, an older driver who was engaging in a series of text messages with a younger male employee. And during those messages, he referred to him as being his bitch, his toy boy, threatened to molest him. Supposedly that was in reference to Cardinal Pell's recent legal issues. The Commission didn't buy that. And also threatened to squeeze his little balls until he cried. So all in all, utterly appalling behaviour, and that again was found to be sexual harassment and found to be a valid reason for dismissal in and of itself, as well as being offensive behaviour more generally. So there's a measure of sophistication in recognising how pervasive and all the different forms that sexual harassment can take.
Hence the reason why this is my favourite topic.
Indeed. And we see that in all of these other areas as well. So with the exception of the top left-hand one, which I'll come back to in just a second, these are all forms of conduct that were held to be valid reasons for dismissal. So you can see we've got Instagram popping up now, we've got text messages, we've got emails. It's a little bit passé now, never thought we'd say that. And then banter. So it's covering quite a range of conduct, and it's also showing a nice evolution. So for example, the bottom middle one, the sexual Snapchat images, that's in reference to a case that happened earlier this year. That was the Fussell and Transport for New South Wales. So Mr. Fussell was a train guard. One night he was engaging in some Snapchat messages with another female train guard and made the comment of, when I'm drunk, I like to send naughty pictures. As you do. She very clearly, very quickly said, do not send me pictures. Very clear. There is no argument, no debate. Do not do this. So he then responded saying that he had taken Viagra, he was home alone, and sent a photo of his erect penis. He tried to backtrack very quickly and walk this back, saying that he really meant to send a photo of his tattoo.
Easy mistake.
Easy mistake, but let's just be clear. The tattoo was not of the penis.
Okay.
It was not on or around his penis. It was not in the groin area. Right. So as far as I recall, it's the forearm. So bit of a distance there.
Right.
So it was found to be a valid reason for dismissal in this case. And this was private conduct, out-of-hours conduct, private phones, done via Snapchat, and yet the Commission was willing to have that fall within the workplace realm. So quite a stretch, from Miller. So from Miller, where we had this conduct happening in the workplace and he's still ordered back into it. In this case, we've got what's essentially out-of-hours conduct being brought into the realm and being found to be a valid reason. Yeah. So we do see quite a change here.
And I think in that case as well, they were friends and there was a suggestion that it wasn't unwelcome, but clearly if she said to him, do not send it, he wasn't ever going to get up on that point. But Jade, I'd be interested to know, do you think that given this range of pretty consistent cases that we would be able to advise clients that you're in a clear position to terminate, provided obviously that you get your processes right? Do you feel that that would be upheld by a commission for this type of conduct?
This type of conduct, I think in this case it was kind of a unique circumstance because Sydney Trans did also have a policy that clearly covered out of our social media conduct. So congratulations, that's why you have policies. I think it's very, very tough. You can never say for sure one way or the other. It's still always a bit of a crapshoot, a bit of a gamble for how the commissions are going to go.
You can't give us a hard and fast rule,
I can't give you a hard and fast rule. I'm sorry. I know I'm failing.
Yeah, I think there's always going to be that bite back, but we'll come back to that in a little bit of time. So the next topic we want to talk about is domestic violence, which I will ask Jade some questions about that. But just looking at these statistics, they really speak for themselves, I think, and they're quite alarming. Some of these are taken just from the 2016 ABS, but the statistic that I found particularly alarming was that 19% of Australian workers who'd experienced domestic violence reported that that harassment actually continued into the workplace. And that same study found that 48% of individuals disclosed domestic violence to one of their managers or supervisors, but only 10% of that 48% that were disclosing pretty sensitive information found their response to be helpful. So it sounds like we've got a long way to go in really being able to handle this. It's been a focus of recent years, so much so that it's now a national standard. It's also reflected in modern awards that you're entitled to 5 days leave in full for at this, which accumulates. It starts at the each of every 12-month period, and that can be taken in a single continuous period. So, if I can turn to you, Jade, what are you seeing from the decisions of tribunals with respect to domestic violence? How are they taking that, and do you think that reflects community standards?
Unfortunately, unlike the sexual harassment cases that we just talked about, the commissions do have a long way to go when it comes to domestic violence. But I think the positive view is I think that just reading from these cases, the commissions want to get there. They just need to find a way through the arguments to actually get to a very similar point. So as recently as 2011, we had the Silling decision. That's the first one listed up there. And this one involved domestic violence that was performed, Mr. Silling was found guilty of. He was a guard, New South Wales Corrections Facility guard, and between 1998 and 2011 he received 3 convictions for domestic violence, 2 against his wife, 1 against his daughter. In that same time frame, he also received a complaint for using force against an inmate. However, after the 3rd conviction for domestic violence, he was dismissed, and the commission the commission did not uphold that as being a valid dismissal, and he was reinstated. And part of the reasoning that they gave for it is they recognised that the community finds domestic violence to be abhorrent, but in this case, it was sufficiently removed from the workplace and they couldn't connect it. There wasn't that nexus or connection to the actual workplace itself. And additionally, he self-reported each of the incidences to his employer, and he complied with all the conditions of the bond that were imposed on it, and there was nothing to indicate that he couldn't perform his job. So that was 2011. Jump forward to 2018, and we have 2, I'd say thankfully, very different decisions. So the first case of Hunt and Kumiala, sorry, I'm mispronouncing that, so we'll just go with Hunt. Hunt was employed, just make this easier for everybody. So Hunt was employed as a trainee health practitioner with an Aboriginal health corporation. As part of his role, he had to actually run a weekly men's mental health group, and part of that was looking at ways to stop domestic violence. He also had to regularly work with domestic violence victims, and yet he was convicted of domestic violence himself. He claimed that it was due to medication and alcohol, and he had a breakdown at the time, but he didn't report it either. So unlike Silling, he didn't report. His employer only found out from his wife's supervisor. So he was dismissed, and that was upheld as being a valid dismissal, essentially because he'd undermined his own credibility. How could he work with domestic violence victims and people in trying to prevent domestic violence when he himself commits it during his employment? And it was also found that would undermine the health corporation's credibility as well. How can you actively try to prevent this in this community when you employ people that commit domestic violence and don't come forward about it?
Well, I think that's a really important point, because it does come back to your values as an organisation as well and what you stand up for, because that clearly is something that the Commission considered.
That was a really strong point, in the Sandilands case as well. So Sandilands was a senior lawyer in the criminal division of legal aid. And again, he was found to have committed domestic violence, again, against his wife and in front of their daughter at the time. Again, he didn't report this. He instead pled not guilty, appealed it, and appealed the AVO. So it kind of bites into any contrition. You can't be appealing saying, I didn't do it, but I'm sorry at the same time. And one of the factors that the Commission really took advantage of, or didn't take advantage of, sorry, really emphasised, is that the nature of legal aid's workforce is to try and prevent domestic violence broadly, to take in a very strong stance. So although Mr. Sandilands didn't actually always work on domestic violence, he was in the criminal law division, the organisation as a whole was trying very hard to take a position and to advocate for the end of domestic violence. So he really undermined his own credibility as well as his organisation's. So they did take a much broader position in looking not just at one person's job. He may not work too often with domestic violence, but overall the organisation does take a very public position in it.
And I think it is showing, though, a very clear trend, because you're going from a decision where they didn't feel that there was a sufficient connection with their out-of-hours conduct to decisions which clearly were connected and didn't reflect their values. And I think also, if you think about community standards, as I said at the beginning, they evolve over time, as do laws. So the laws, if they remain static, they become archaic. So they have to evolve as well as community standards do. And that's just reflected in the fact that we do have now these national standards to deal with domestic violence.
I think it'd be interesting also, just with that before we jump on, all of these have looked at physical violence and physical-based domestic violence. I think it'd be very interesting to see how the Commission handles it whenever they get hit with a case that involves emotional, psychological or financial abuse, to see how their reasoning applies to that. If they're still relying on this nexus to the work, how they can stretch to get to that point.
That's a very good point, because the definition of domestic violence does extend beyond physical violence as well. So finally, one of the last topics that we wanted to talk about when it comes to misbehaving employees is, we've obviously explored in some detail, the usual suspects when it comes to bad behaviour, racial comments and sexual harassment, domestic violence. But what about just broad brushed unacceptable behaviour, which doesn't really fit within one of those sort of definitions?
I'd be sacking that guy. I reckon.
So
That's valid.
what do you think he did?
I don't
So-
want to know.
Don't need to have an investigation into that, I don't think.
Show of hands if anyone thinks that's unacceptable.
Oh, I'm a little worried about the
you're
lack of hands there.
Okay, so I really like this comment as well. This is taken from one of the Queensland Commission decisions, where civilised interaction should be expected and the need to revert to barbaric and aggressive behaviour should not be expected. So, this is really where we're talking about that behaviour where people are either criticising their colleagues, management, anything that could be undermining management, just things that are offensive and inappropriate really in the workplace. But it's hard to gauge what community standards are when it comes to this type of behaviour, but it would be interesting to see what Ryan thinks of that, and also just to hear from Ryan as to how that is being played out in the Commission.
Yeah. Well, unacceptable behaviour is obviously a pretty broad topic, and it covers a lot of different areas. The three, and I would say this represents a bit of a trend. The first decision is 2016. Now, that was a decision where an employee of BHP was sacked for, he was involved in a bit of a bust-up, a verbal bust-up, where he called someone, he says a scabby bugger, they said he called him a scab. Now, BHP, a very industrialised workforce, the phrase scab is obviously very, has a lot of connotations and a lot of history to it. That dismissal was actually found to be unfair, and so the Commission considered all the points and decided that it was relevant that someone else had said some choice words to him at first, and so that was his response. It also found that despite some decisions talking about the importance of the meaning of that word, Mr. McDermott did not know that, well, whether or not this is true, Mr. McDermott did not know that the word was so offensive that it could result in him being dismissed. So they bought that excuse from him. So that was 2016. We jumped to 2019, and we have a dispute in relation to a thermostat at a workplace. Has anyone ever had a dispute about someone putting the thermostat or the aircon too cold or too warm? Yeah. Who likes it cold? Right. Who likes it? Okay. So Ms. Bastoni had jumped up in the workplace and was imposing her human right of having an acceptable temperature, and yet her colleague jumps up and says, "Hey, it's fine, leave it as is." Ms. Bastoni's response is, "Well, it's fine for you because you've got natural extra padding." Yeah, right. And so the colleague's like, "Excuse me." Ms. Bastoni doesn't apologise. She doubles down and goes, "No, scientifically, if you've got extra padding, you don't feel the cold as much." So she tried to, literally in the unfair dismissal case, I probably shouldn't laugh, but she brought scientific evidence that, you know, just of her own Googling research, I suppose, to show that extra padding means that you don't feel the cold as much. Strangely, the Commission didn't buy it. They said, no, you can't be having a go at people for their bodily, I suppose, makeup. And so we had a situation there where she was sacked. Now, they had a very good policy against discrimination and against harassment and bullying, as I'm sure and I hope all of you have in your businesses. And they were able to rely on that policy and say, well, no, we don't accept discrimination in all its form, and that's not acceptable to be referring to the extra padding or otherwise of your colleagues. Which is a shame because, you know, she just wanted to keep the temperature right in the workforce. So it's not a shame. We jumped down to, just to clarify there, we jumped down to a case involving Mr. Alex Perry and one of his workers, and someone had a go at his workmanship. And the gentleman started yelling, swearing. There was all sorts of comments, including "I will f you up the buttocks," and the guy obviously he was a clicker. Then that continued in the HR meeting where he gets given a show cause letter, throws it back in the HR manager's face, and says, "No, swears. I want to speak to Alex. He thinks I'm wonderful." Mr. Perry gave evidence at the Commission that he didn't think he was wonderful, so that kind of undermined that theory, and the dismissal was found to be valid and not unfair for what Deputy President Sams called appalling conduct. So, last case there was a man who, I don't know if anyone's been to San Remo down in Victoria, down in the Gippsland, beautiful region. There's some pelicans that come up and they're fed every Tuesday afternoon. This guy had been employed for about 20 years feeding them, but his only employment was that 1 hour every Tuesday afternoon. So he literally was earning like $29 a week or something. He had this bust up with his manager where he used the F word. His manager came back and said effing, as in E-F-F-I-N-G, and that actually was a relevant part that the Commission had to consider. Is there any difference between the word, or is it just the intention of the word? If Urban Dictionary literally looked at it, Urban Dictionary describes effing as meaning the same thing as the word that it's meant to not be saying. So that employee, very unique circumstances, 1 hour a week, had been doing it for 20 years, and it obviously, if you're only working 1 hour a week feeding pelicans, it obviously has a very close, you had a very close connection to the role, and it was found that he actually used the swear word as an adjective, not at someone. So there you go. It's a fascinating read if you want to have a look at that San Remo decision. Say all that to say that unacceptable conduct comes in lots of forms. Generally, if there's a bust up in the workplace, it doesn't have to be physical, but if there's swearing at someone or calling names at someone, or generally the Commission is willing to find, policies help, but they are willing to find that in general, that conduct, you don't need to be told that it's wrong.
Yeah.
It's not acceptable in the workplace, and so therefore, if you dismiss for that conduct, it's often been found to be valid.
Yeah, I think that's a good point. Policies do help, your values help, but common sense also goes a long way. If the common sense approach is that doesn't seem to be acceptable, then it probably isn't. And can you take us through mitigating factors, Ryan? So we can see from the start that it's a complicated jurisdiction. So we've got the concepts of valid reason and harsh and unjust and unreasonable, where you might find that it may be the determination. This is actually, it's probably worthwhile quoting from this case because it was a High Court case of Byrne, and it's versus Australian Airlines, which is regularly quoted from, but it explains the reason why this jurisdiction can be quite tricky. It says, it may be that the termination is harsh, but not unjust or unreasonable, unjust, but not harsh or unreasonable, or unreasonable, but not harsh or unjust. In many cases, the concepts will overlap. Still confused? Understandably. So in short, a dismissal must be for a valid reason, follow a fair process, and properly considering the individual circumstances. Ryan, can you talk to us about some mitigating factors.
Yeah, so we've got some things on the slide here, and if you don't have a set way of considering these things, these are general topics that you should be considering and giving thought time to before making a decision to dismiss someone. Now, we start up there with age and length of service. Those two are often linked. If someone's old, often we find in the cases, they also often have the, I don't want to use the word excuse, but sometimes they use it as explanation that they've been there a long time or as a mitigating factor, they've been there a long time. Now, does someone having been in a workplace a long time and old, does that excuse all conduct? That's a fair question. And in the past, we often found that was a big mitigating factor, that if someone had exemplary service, it's often described as, over a long period of time, then they could almost get away with anything. We are seeing a bit of a swing away from that. So we've had a few cases that we've run recently. One I'm aware of in the Industrial Relations Commission, so for a health district, where an employee had been employed for 11 years and used that explanation. I've been there a long time, great service, but he didn't follow the policies, and it was a mental health setting, and so Commissioner Sloan found that, well, you should have known better. So that we're seeing sometimes a switch back to go, well, not I've been there a long time and so therefore I should get another excuse, but in some situations, particularly in relation to safety and in relation to that setting was a hospital, following policy is very important, and so long service can mean you should have known better. We had a similar case where it's currently on appeal, but it's a case by the name of Singh, S-I-N-G-H. He was an employee of Sydney Trains, long time, very old, and no real disciplinary issues to speak of, but he was involved in a safety event, and there was a near miss, a couple of near misses, where he was on lookout. And the Deputy President Sams, in a very long judgment, there's some light reading for you if you want to have a look at it, but it's many, many pages, said, well, he actually should have known better. He'd been there a long time, and safety mistakes are not necessarily excused just by the fact that someone has long service. If we then look at other matters, we look at policy, and this is the point we come back to before about, do you need a policy to tell someone that that certain actions are wrong, and that probably partly depends on what the actions are, and obviously some policies you are required legally to have. But Deputy President Sams, I like his quote from a decision which is named Natoli, N-A-T-O-L-I, versus Anglican Community Services from last year, where he actually stated that no employees need training to realise that threatening and harassing a subordinate employee, particularly without evidence, is the wrong thing to do. So we're again seeing some decisions to say that, well, while you need to consider all of these mitigating factors, and contrition's another one, and whether or not they've been trained, and whether or not their economic circumstances will be harshly affected by them losing a job. I mean, they will in every single case, and there's been decisions to say that how much weight you give to that is a bit tough, because in every case where someone loses a job, it's going to affect their economic and personal circumstances. But the long and the short of it is that both the Industrial Relations Commission and the Fair Work Commission are needing you to consider these points, but they're not necessarily saying that people get a free hit because they've been there a long time, because there's no specific policy for it, and because they're old or their economic circumstances are going to be affected.
Yeah, I think they are. They're really undertaking a bit more of a critical assessment of each of these mitigating factors, rather than just sort of ticking a box and saying that you have got a long length of service, etc. I actually found a really interesting quote from that Natoli decision as well that Ryan was mentioning, which is worth probably remarking on. The fact that an employee might be a very competent and have no issues relating to their performance does not mean the employee can rely on that history to exculpate a serious incident of poor judgment, or a breach of policy, or an ability to get on with others in the workplace, or treat them with respect and bad temper. And that sort of really summarises the position of the Commission, and I think that does reflect community standards. You can't just within the community engage in that kind of offensive behaviour and we're now hearing from the Commission that that's, you know, reflected in those decisions. So I've got some just to summarise really what we've seen coming out of the Commission, some really 5 takeaway points that I would want to make, but I do want to also then throw to you to ask some questions. And of course for the people online, you've got a speech bubble which you can type in any questions that you'd like to ask as well. Really, I think where we get to is it doesn't seem that the Commission has gained, it does seem the Commission's gained a level of maturity towards cases of sexual harassment. So there's a clear trend. They're getting tough on such behaviours. I'd probably say that for reasons unknown, the Commission's not as tough on racial remarks. So you're really finding that the decisions are patchy. That I think is an area that needs to change, and I don't think it's reflecting public sentiment. And really, at present, I call it the no idiots policy. I wanted to say something a bit stronger than that, but it's something that the Commission doesn't currently have a no idiots policy. So there are, you can be an idiot. I know at music festivals there's a no idiots policy. But gone are my days where I go to music festivals. But you just, really the point there is that you should be, as a business, allowed to stand up for what are appropriate behaviours and that they reflect your values. And I would have thought that the Commission does seem to be less tolerant of those behaviours and the impact that they might have on others. Mitigation, of course, as I said, is still being looked at. Well, it must be looked at, but it's also just being looked at more critically. And then really, it's just beware of the bite back. So it might be that you stand up for, or perhaps the best example would be the Bramley decision in Australia Post that Jade talked to, where the person distributed pornography. So it used to be pretty clear that that was unacceptable. But then you have this decision where the Commission's really coming out and there was the decision to terminate wasn't upheld. So there's no real absolute rules. And I guess the bite back might be that we might see a similar position with sexual conduct. So you still have to, it's not just a free ticket where you go, okay, this is what's happened, we can terminate, and the Commission's going to support us in that decision. That might not actually eventuate. You just have to always be mindful that there might be a bite back. So my tips, though, to avoid that bite back would probably be just to stand up for your workplace culture, make it sure it's appropriate and fair, be consistent and decisive with your views on these actions, particularly be consistent. You don't want a situation where you treat one person one way and another person another way. And then just really consider any of the other issues that might be at play. Is there all of a sudden personal circumstances that's led someone who has always been a sterling performer, has never engaged in any outbursts to, they might have a mental health issue as well at play to all of a sudden act in a way that is not common for them to act. And really, then I just want to ask, we've got 5 minutes for questions. Please don't be shy.
About Robert Solin earlier on. At what point does someone represent the company versus having a private conversation? So you were talking about I think it was at the time, the Aboriginal woman on the bus.
Yeah.
So I'm assuming he was the driver, I'm just putting things together, he was the driver talking to another passenger, but he's still representing the company. At what line is it a personal conversation and still working for the company?
It's an incredibly blurred line. I tend to think that decision was wrong, but it doesn't mean that it's not a decision that's been made. So in that decision, he was on a bus. I don't think he was the driver. I think he was a passenger chatting to a mate who they were having a discussion essentially about a sexual exploit in relation to an Aboriginal woman. And he was talking about in very derogatory terms, using a phrase that was it's incredibly inappropriate. And so the Commission just gave, in my view, too much weight to the fact that it was intended to be a private conversation, even though it was on a bus. There are other Aboriginal people on the bus, whether or not that means anything anyway, because it can still be offensive to people that aren't of a particular race. What line does it become their representative of the company? Look, it's a really hard one. It's a really hard one. That is a bit of an older case. So in that we're not talking a long time ago, but I think it was 16 or 17. I would hope that it would actually be decided differently in 2019. But again, as Deanna says, it's really tough to know. There's perhaps a golden standard about the way to go about it, but it's not necessarily going to be endorsed by the Commission.
Yeah, I don't think a lot turned on the fact of, the question of, are you representing the company per se? Because they were clearly at work. It was a bus that had all the workers on it, and there were other workers on it as well that overheard this conversation, but more so it just turned on the facts of, was it meant to be overheard, and also the order within which the comments were made. There was a lot said in the decision about that. So I think it's wrong as well. I don't think it would be decided this way. I think it was really offensive, not just racially, but also sexually. And I think they were within their right to terminate, and it should have been supported by the Commission. Does anyone else have any questions? With the mic?
The one on the webinar?
Where?
Webinar.
Might be a webinar question. Oh, Anne-Marie.
Hi. Just with regard to these decisions that have been upheld, unfair or harsh dismissal, what sort of impact does procedural fairness have in these decisions? Where they've been upheld, has the company followed procedural fairness? Or is it just looking at whether the decisions...
It depends. Look, I think it's a very important factor, but you do tend to find... There was a decision that I know Jade did talk about where there was
a Parker decision where the actual conduct itself was found to be sexual harassment and bullying, valid reason to dismiss, but they completely blew the process for it. So...
Which is normally what happens,
Often. Say no one. Let's just say give us a call first next time. But it's the process itself is still important. You can't have one without the other. You do have to have both of them working hand in hand and working together.
Now, it wasn't a huge decision.
No.
You didn't get reinstated. It was something like 3 weeks was
I was
awarded.
3 weeks salary, so just under 7,500. So it's not a massive amount of damage. It's not reinstatement. But still, it's risky ground at any time to dismiss anybody and just completely ignore the procedures and ignore natural justice. It's always a risk.
Hi, just wondering if you could comment on the decision in Banerjee, where the public servant was critical on social media of government immigration policy. In particular, if there are any circumstances that might have led to a different decision in that case?
Oh, yeah.
There's a lot of circumstances of that case.
Yeah,
it's a pretty unique environment, given that the APS and the policies that were at play and the requirements. I mean, when something goes to the High Court, it's because there's pretty arguable positions on both sides. For those that aren't aware, there was a comment to the decision of Banerjee that was handed down earlier this year, where a public servant made comments on Twitter in a pseudonym. So her name was La Legale, and by looking at the Twitter page, you wouldn't have known the identity of the individual. She had thousands of Twitter comments, most of them out of the workplace, in that most of them were at night and not using a work computer or anything, but she was dismissed. The High Court, for a range of reasons, found that dismissal was permissible, so it wasn't overturned. In order to get into what I would say, I would direct you to some resources we've got on our website about that decision. James Matson has a great interview where he was actually interviewed on ABC News about that decision. So if you're interested in it and how Twitter can affect the workplace, I would say in order to try to give it justice in 30 seconds, I'd refer you to James's videos about it. I think it's probably the wisest decision.
Or hit him up after this seminar.
Yeah, we'll have a chat to James, that's right.
I'm looking for him in the audience, but I can't quite see him right. Well, thank you very much for your active participation. I really appreciate it. It's obviously a topic that is of interest to people. More than happy to take questions after this as well. Thank you.